Welcome to Heald Law Academy, the place where you can quickly learn how to maximise the value of your businesses and safeguard your commercial and personal interests. I'm joined by David Dees, and we're going to take a look at what happens to share capital when you don't have the right kind of shareholder agreements in place. Firstly, David, for those who don't already know, what is a shareholder agreement?
The shareholder agreement is an agreement between shareholders. That may be the statement of the blindingly obvious, but I can illustrate what happens if you don't have one.
What tends to go wrong with them?
A good example, some people came to see me only recently where somebody had been involved in the business, working every day in the business, had shares. He then left to go and work for another company. Could have been a competitor. He was able to keep his shares. And they said, how can this be true?
How can that be true?
No longer working for us, and yet he keeps his shares. So obviously I asked them, did you have a shareholders agreement? And they said, what's a shareholders agreement? A shareholder agreement can regulate that relationship. You can do lots of things with the shareholders agreement. You can state how many shares people have, when they can get more shares, but most importantly in this example, what happens if they leave? And there are provisions that you can put into the shareholders agreement, if you thought about it at the beginning, which will mean that you can take those shares from that individual when they leave.
So in this situation, this gentleman was perfectly within his rights to leave to potentially go work for a competitor and take his shares with him?
Absolutely, yes. Shares are property. If you have a share, you have a piece of property. You can't take away that property any more than you can take away someone's car. It's their right to have it. You know that lots of people have shares in listed companies. They just keep them. That's their property, and they're expecting to get some dividends from them. They might even be able to sell them for a profit if they appreciate in value. And it's the same with a private company.
So these are really important things to have in place. And how easy is it to have one established?
Well, it's very easy if you think about it early on. What you don't want to do is give shares to somebody and then ask them to sign a shareholders agreement after they've already got the shares.
See ya.
That's right. Well, they may be very happy with that, because if they've got a commercial relationship with you, for example, if they're working in your business, that's fine. They're probably going to sign. But if you leave it too long, the relationship may have soured, and then it's virtually impossible to get them to sign it afterwards.
And from an individual point of view, these are they important to protect your shares from a personal point of view as well, or just from the business side?
It's both. It's always both, because of course a lot of companies, when they start out, the difference between personal property and company property is very, very close, because the company might have quite low level of assets as it starts out and grows and develops. So there's a great deal of coincidence between the ownership rights and the business rights. It's only when companies get much larger that there's a real separation between shareholders' rights and what the business does. So for owner managers, it's absolutely critical that they get it right.
And who has to initiate this, the company, or can an individual go and approach you and be like, I want to set up a shareholder agreement?
It's invariably the existing owners of the business. The sort of situation you've got is actually when two people come and see us because they want to start a business. Somebody may have an idea, somebody may have some money. They put them together, they need a shareholders agreement. So they will then put money into the company to get it going. They'll take shares in return, but they need an agreement to decide what happens in case they fall out.
And can you amend this agreement? So let's say, like you previously mentioned, a company starts off small and then all of a sudden it's the next Google or Apple.
Absolutely, yes.
Can they then change the agreement to amend accordingly?
Of course they can, yes. You can bring in new shareholders. Typical situation is when a company's got to a certain size, they need more funding, and they might have to bring in outside investors. In those situations, the investors will want a shareholders agreement, often on their terms, but the thing is becoming more complicated, there's more regulation, but everyone knows where they stand.
And I've heard a lot about people sort of almost getting a shareholder agreement off the shelf. Do you advise this?
It's up to them, they're very cheap. The problem is that they don't understand the nuances involved, and they won't always understand what it is that they're completing and filling in. Look, if you had an important illness, you wouldn't go and ask your friend next door, you'd go and see a doctor, wouldn't you?
So it's best to seek professional advice in this case?
Of course it is, yeah. Because often the agreements that are taken from the internet and filled in actually only work so far.
And are people able to come just for advice if they need, a few questions answered?
Sure,
Yeah?
sure, absolutely. We're very happy to talk to people. If they don't want us to do anything, that's fine. They can go away and sort it out themselves. But at least we can give them a steer at the beginning. But particularly with startup businesses don't want to incur a lot of cost, but they might need a lot of guidance. And you can give them a menu of things that they need to start with. One of those will be a shareholders agreement.
Is this something that a lot of people aren't aware of? Do you see a lot of people coming in, like the example that you gave, saying how come they can leave?
Yes, people are not aware of it. People are very surprised because they make an association between working in a business and owning the business that is actually completely spurious, because of course you can work in a business completely separate from shareholdings, or the converse applies. You can stop working in it and keep your shares, and people just get the two confused.
That's a good deal though, if you just keep your shares, move along.
It is.
Wonderful. Well, thank you so much, David. We hope you enjoyed today's discussion. If any of the issues mentioned are affecting your business right now, then simply call David on the number below, and remember to subscribe to all of our videos, and we'll also send you news of seminars and other events where Heald Law Academy will be presenting. Bye for now.